Students, let's start with this particular point. Okay, that's fine. Share me the link. So now, students, we'll start with this session. The 11th particular class for the CA final, direct tax, November 21, May 24, November 24 attempt students, and the CMA students who are appearing for June 24 and November 24 or December 24. Now students, the last lecture we have introduced ourselves with this concept of business connection in India. This was the last particular point that we did discuss, isn't it? So therefore students, the entire point of the discussion and the negotiation is this particular point, which is what is the business connection, students? The meaning of which I have given you a general meaning in terms of the 3 case studies that we have discussed yesterday, and you have realized that the conventional meaning or the general meaning of the term business connection is that in the phase number 2, which is you have a case of a branch or a factory or an office or any other establishment which is situated in that other country. That is what will be referred as what? That is what will be referred as a business connection. And in fact, I had also taken you to the India-USA double taxation avoidance agreement treaty, in which case you have realized that in the treaty they are using the term permanent establishment. So permanent establishment versus the business connection. These are the 2 aspects that you should always bear in mind, and on that basis we have done our discussion and conclusion. So now students, one particular point that emerges over here is this, in this context. Primarily, the meaning of the business connection which is given to us in the Act. And if you see over here, the term business connection has been included with something and excluded with something. So far as the exclusion was concerned, you would have realized that in all the cases they are using this particular term, which is the term that has been used is confined to, that is restricted to only this activity. This is a classic phrase that they are using it in this regard. So it therefore means that any further activity, if at all has been pursued, any further activity, if it has been pursued, then in that particular case, it will not be the benefit of the exclusion will not be available. And we have given some examples also yesterday. Then the includes part of the definition, students, there were 2 things which I have taken you. If you remember the chart that we prepared yesterday, there was a dependent agent who performs any one of the specified activity. That is the one. And the second one in the include part was the significant economic presence of the non-resident in India. Significant economic presence, and in the significant economic presence, I have given further 2 bifurcation, which was the turnover criteria and the number of user criteria. That is what I have discussed with all of you yesterday. Now, not discussed, but I have given you the chart in this case, isn't it? Now, on that, students always bear in mind, in this case, the dependent agent is a person who mainly or wholly acts on behalf of the non-resident. Dependent agent. Who is a dependent agent? Dependent agent is a person who mainly or wholly acts on behalf of the non-resident. Okay. Now, so there is one very dangerous section which you will encounter very soon. A dangerous section which is also there in your textbook. This first booklet number 1. The agent in India is considered as a representative SSC. Just only write one sentence of that. What is the meaning and what is the implication? The dangerous meaning and the dangerous implication that you will learn in one topic. Right? Below that itself you can write. Quickly. The agent of the non-resident is considered as what? As a representative SSC. What is this representative SSC? We will see as and when the time will arrive. Now students, if you want to use the sticky notes, are you aware of sticky notes, that yellow color? That also you can use it to stick those sentence one-liners, whichever is being given in your textbook, so that it becomes as comprehensive as possible for all your revision aspect. Let's proceed. Now, one last observation before I start the discussion for the today's class. One last observation was about the license office. Be careful about this license office. I told you something about that yesterday. If it is only preparatory and auxiliary that this license office is performing in India, then there is no business connection. Only preparatory and auxiliary. Isn't it? However what? However, students, if it is more than that, and yesterday we gave some examples of what is that more than that, initiating the negotiation with the potential customers in India. So if you started negotiating with your potential customers in India, then you will no longer be considered as a license office. You are a license office, but the benefit of exclusion will not be available. The benefit of exclusion to the definition of business connection will no longer be available. Is that point clear to all of you students? That exactly is the point. Now, let's enter into the discussion about the second inclusion to the definition of business connection, which is significant economic presence. The students, you would be aware of this fact. Business connection, if you see yesterday's that 3-phase which I gave it to you, 3 phases, and in phase number 2, the non-resident has established branch in India. The non-resident has established what? The branch in India, and accordingly we have considered that the non-resident has a business connection in India. That is what we discussed. Therefore what? The term business connection in a way is presupposing a physical presence of a non-resident in India. So there needs to be what? A physical presence of whom? Of a non-resident in India. That is what we are coming to know about it. In fact, even the permanent establishment definition that I made you refer yesterday, even in that case, there was again the same requirement. Branch, office, factory, etc., etc. Depots. What it is? Nothing but a physical presence. That is what constitutes permanent establishment. That is what constitutes business connection. That is what is constituting business connection, isn't it? However, now be careful, students. In the COVID time, you all are aware what happened in the COVID time. All the shops and all were done, and everything was on the internet. Buy the goods where? From the shop? No, from the internet. Or from the app. Download the app. Which app? Many apps you have downloaded. From where you buy the goods. Blinkit. Which app you all downloaded in the COVID time? Other apps? No matter. Big basket, yes. That is also the case. All the otherwise, you were the only one who used to go to that shops and all. And then suddenly you stop going to the shop. Everything now you are calling from that particular app, and that exactly is the game. What has happened? That physical presence is no longer necessary. See? Alibaba. Physical presence is no longer necessary now. And therefore, that non-resident, say for example, even a departmental store. I may not have a departmental store. I may not have a mall, a fashion store. Everything is on the app. You decide what you want. The goods will be delivered to you. You decide what you want. Select it. Get delivery at your home. So now I don't know from where that person, now some particular product, that product may be coming from London. From Turkey, I got some product from Turkey, it was coming. I never knew that it is coming from Turkey. I just purchased it and it came from Turkey. And therefore, physical presence therefore became irrelevant during these COVID times. It was a big eye-opener that just because there is no physical presence, then the danger would be that there will not be a business connection in India because of the lack of a physical presence. But is there a significant economic presence of that person? Yes, he is doing still a turnover of many lakhs of crores of rupees. So that person has a significant economic presence, but no physical presence. So the government thought that it is very high time that, fine, physical presence is there, that is okay. But it is high time that now we also recognize a significant economic presence as a giving rise to business connection in India. As giving rise to business connection in India. So what is this physical presence? Sorry, what is this significant economic presence? So therefore, in a case where there is a significant economic presence, the physical presence will have got no relevance. But you say, but sir, if there is a physical presence, but there is no significant economic presence, then what? It is already a business connection. I set up a branch. For the last 2 years, it is only doing business of 2,000 rupees. So it doesn't matter. Then we don't look into the significant economic presence. Because the general principle is what? That if you have got a physical presence, you have got a business connection. So significant economic presence is not introduced to override the physical presence. Significant economic presence has been introduced as an additional criteria which can lead to the existence of what? A business connection in India. So it is like an additional criteria which may lead to the existence of a business connection in India, even if that non-resident may not have a physical presence in India. If there is a physical presence, we don't see any turnover and the number of users, those have got no relevance. But if there is no such physical presence in India, then we see how much is the economic interest of that non-resident in India, and on that basis we decide whether that non-resident may have a business connection in India or not. Is that point clear to all of you students? So therefore, now the excitement is building up. What then constitutes the significant economic presence? I want all of you to read this point number A and point number B. So that highlight, did you see where I have highlighted? Shall also constitute. Shall also. That is the reason why I told you, no? This concept is not introduced to override. This concept is not introduced to override. Override what? The physical presence criteria. This is over and above. So if there is no physical presence, then check out. Check out what? That whether a significant economic presence is there in India or not. And if there is, then in that case, this will give rise to a business connection in India. So what it is? Be careful about the terms. All of you. Transaction in respect of any goods, services or property carried out by a non-resident. Be careful. With whom? Don't use this word. With any person in India. A new phrase. Although this has not been explained. But a new phrase has come. Up till now, the phrase that we were conversant with was resident in India. Are they using the word resident in India? Is it therefore that in this case, the transaction that you are undertaking, undertaking with what? With any person resident in India? And the answer is no. And the answer is no. So this is one point that you should always bear in mind. That the transaction with any person in India has got absolutely no relevance. Fine, students? Has got absolutely no relevance. Now, coming on the second point, which is an important one. How do we decide that this is person, that non-resident is doing the transaction with any person in India? How do we decide that? Any clue with this? How do we decide that the non-resident is doing the transaction with any person in India? Person can be now anyone, need not necessarily be a resident in India. He can also be a non-resident. Say for example, the non-resident is doing a transaction with Mr. Shah Rukh Khan. Shah Rukh Khan is a non-resident right now because his stay outside India was more as compared to the stay in India. So technically right now he is having a status of a non-resident. Shah Rukh Khan has ordered something from one departmental store which is based in London. Harrods departmental store. Biggest, one of the most famous departmental store in UK, London. Harrods departmental store. So from there he is bringing some goods. Mr. Shah Rukh Khan in India right now, he is a non-resident having a status of a non-resident. So whether that transaction of that non-resident, which non-resident? Harrods departmental store, that Harrods departmental store which is supplying the goods to Mr. Shah Rukh Khan, who presently in this year is a non-resident, will that this transaction also will be considered in the threshold of this rupees 2 crores? Whether this transaction will that also be considered in the threshold of that rupees 2 crores? That the answer is yes. Because is he a person in India? And the answer is yes. So how do I identify? Identify that if supposingly the non-resident is supplying the goods or services to an address in India, so obviously it will have an address, no? The delivery address would be there. If the delivery address happens to be where? In India, in this case, it will be what? It will be considered as a supply of goods or services where? In India. Supply of goods or services where in India. Is that point clear to all of you students? So address is what is required. Not that the person should be a non-resident or a resident. That is absolutely not considered. So please be careful when you employ the languages in your answer, because you will have to write the answer. Non-resident supplying the goods or services to any person in India. Fine. And what should be the amount? The amount, the aggregate of the supply to all the persons in India during the previous year should be how much? Should exceed Indeed, should exceed rupees 2 crore. All of you are aware of it now. Should exceed rupees 2 crores. Exceed greater than. Remember, now the build-up is happening. Active business. Passive income should be less than 50%. Active business. In that, the passive income should be less than 50% or up to 50% or more than 50%. Passive income for active business outside India it is, should be less than 50% of the total income, up to 50% of the total income, or more than 50% of the total income. When the business would be considered as active, when the passive income is less than 50%, up to 50%, or more than 50%. It is up to 50%. Means greater than or less than or equal to. Less than or equal to. And the outside India, in that the presence of the asset in India, employees in India, and the payroll in India should be up to 50%, less than 50%, less than, there it was less than. Significant economic presence for the turnover criteria should aggregate of the supply by the non-resident to any person in India should be more than 2 crores. More than 2 crores. Now, are you getting the feel of it? What the situation will happen on the day of the examination? And now the last one, point number B. Okay, first let me explain point number B. Remember, everyone say, download the app. Netflix, all the app, everyone wants you to download it. They don't want to sell it right now. You say, download the app. Jio, people are finding, everyone is in Jio app. This app, that app, download it. Every companies or this one, they say, kindly download the apps and all. In this context. So what happens now? If you download the app, then what happens? So if you download the app, in this case, they are not selling anything, but they understand you people are the potential customer now. They understand what? You are the potential customer. Today you will not buy anything, but tomorrow you will buy something. Because they will keep on putting the offer. This offer, that offer, Diwali offer, this offer. So this offer will always keep you preoccupied that okay, I should be opting for it, isn't it? And therefore, in that case, what is required is that if supposingly, if a non-resident, they may have made an app, and through that, that is a digital means of interacting with whom? With the user in India. And the number of user in India is how much? At least 3 lakhs. In India, the number of users who have downloaded their app is how many? At least 3 lakhs. Netflix comes in this category. Netflix comes in this category. You can go to the net, you can download the Netflix and you will find a lot of free content. Okay, but they understand some premium content we will keep it at a price. Paid content. And one day or the other, how much time you are going to resist it? At one time or the other, you are going to buy it, subscribe it. Isn't it subscription? That's subscription model. You subscribe it. And that exactly is the game. So there is the number of users who have downloaded the app in India is how much? At least 3 lakhs. See the game here. There you don't say more than 3 lakhs. At least 3 lakhs. So greater than or equal to. This issue definitely is going to come, students, for sure. And therefore I have made a particular entire chart of all these thresholds. This is going to help to all of you later on. Right now I'm not sharing with you because it has got no relevance at this stage. But later on definitely I'm going to share it. Okay. With that, students, you can see we are done with this. One question we just want to do with all of you. And be careful now. One question. Yeah, question number 4, students. An ICA question. Read this question, MCQ of the ICI. An MCQ of the ICI, students. Question number 4. Read it once. Don't see the answer, but let's see what you all do it. All of you through with this one, please? So what is the answer? Indeed. The answer is A, students. Can you see that? How the game is twisted. Now, many students, while they read question 4 at that point of time, their mind would be in the agent part only. So this, okay, MNO has got a dependent agent, and the next one PQR has got independent agent, and therefore MNO has got a business connection. PQR does not have a business connection. Don't do that. Dependent agent is being satisfied by MNO, and significant economic presence is satisfied by PQR, and hence both of them are having a business connection in India. Both of them are having what? A business connection, students, in India. Is that point clear to all of you? So that exactly is the game. Okay. Right now, successfully, you people have given the answer, because just now we did the significant economic presence. Had it been a gap, and your mind would be only traveling to that agent part at that stage, This question would be really, oh, what is that? Fine, students. Okay, let's then take it further now. Shall I now go to my next concept? We are done with this and the last concept now, student section 911. And what exactly is this? The last one, students, now. Transfer of what? Of a capital asset situated in India. The biggest concept now which is coming across over here with all of you. Obviously, students, it is such an advanced concept that it needs to be addressed systematically. Okay, so you can give the heading in this if you want in your notebook. So, like income 911, we're doing 911 only. So, income is deemed to accrue or arise in India if it is in relation to the transfer of if it is in relation to, I can use the word inter alia also if you want. If it is in relation to, comma, inter alia, comma, transfer of a capital asset situated in India. Fine, students? A capital asset situated in India. So this is the provision. Now we will look into various case studies. In this case study number 1. So students, what is the scenario is that this is India and this is USA. So XINC dot of USA, in this case, what they have done? Point number 1. So there is a shares of RIL, shares of RIL, Reliance Industries. So yes, purchase the share at rupees 100 per share. At rupees 100 per share. Thereafter, students, what they have done? Second point, sold the share. So sold the share at rupees 250 per share. Sold the share at rupees 250 per share. So the question over here is what? Whether the capital gain of rupees 150 per share, the capital gain of rupees 150 per share will it be deemed to accrue or arise in India? This is the question. Copied. So what is your take, students, in this? The capital gains of rupees 150 per share, will it be deemed to accrue or rise in India? Will it be deemed to accrue or rise in India, students? So the question therefore is, had you transferred, what is this 911? Transfer of capital asset situated in India. This is what we need to see. To decide whether there is a deemed accrual or not, we need to check that whether the transfer that has taken place in this transaction between X and Y INC dot, is it in relation to a capital asset? Is it in relation to a capital asset which is situated in India? This is what needs to be seen, students. So what is your take on that? What is the capital asset over here? Subject matter of transfer of the subject matter of transfer is a capital asset. Which capital asset they have transferred? Shares. Is the shares situated in India? How do we decide that where the shares of a company is said to be situated? How do we decide where the shares of the company is said to be situated? Where it is situated? The shares of a company is said to be situated at a place where the company is incorporated. And where RIL is incorporated? In India. So therefore the shares of the RIL is situated in India. Therefore, irrespective of where the transaction of this transfer has taken place, because the transaction of this transfer has taken place in USA. So it is irrespective of where the transaction of this transfer has taken place. It is also irrespective of who is the transferor and the transferee to the transaction. Who is the transferor and the transferee to the transaction? We will say and conclude that the transfer of the capital asset being the shares of an Indian company will result into a capital gain which is deemed to accrue or rise in India. Is that point clear to all of you, students? Please take a note of it. Point number 1 of this answer. Point number 1, students. The share of a company is said to be situated. The shares of a company is said to be situated at a place where the company is incorporated. At a place where the company is incorporated. Full stop. Therefore, the shares of the RIL is said to be situated. The shares of the RIL is said to be situated in India. Is said to be situated in India. Full stop. Point number 2. Accordingly, the transfer of the shares of the RIL, transfer of the shares of the RIL, shall result into capital gain, which is deemed to accrue or rise in India. Capital gain which is deemed to accrue or arise in India. This full stop. This is notwithstanding. Point number A, where the transaction of the transfer has taken place. Where the transaction of the transfer has taken place. Or point number B, who is the transferor and the transferee? Who is the transferor and the transferee in the transaction? Who is the transferor and the transferee in the transaction? I hope that all of you are clear with this one now. Every one of you. Now, X INC dot product became now very careful. We came to know that in this case, it's very easy for attracting the tax in India. So do you know what X INC did? He now became quite smarter then. And what was his smartness? His smartness now I'll tell you. What he is doing. So here now, be careful to the what he is doing. So here it is India. In between, can you see that? In between, another country came into picture, which is Singapore. And then anyway, you are there in USA only. The architect is your X INC dot. The architect, students, who is the architect? The architect is X INC dot. So what is this architect has done? Let's see. So X INC dot, over here, be careful, students. In this context, he has set up a company which is based in Singapore. And the name of the company was ZPLC. Company based in Singapore, and the name of the company is ZPLC. So what he did? So obviously, in this case, share capital was being introduced. So we will say 90% subscription. Share capital, say in this case 90%, it's a 100 crore. 100 crore. This is a share capital of rupees 100 crore. Then thereafter, what you have got? Cash or bank of again 100 CR. Cash in bank of again 100 CR. So therefore, students, cash in bank of 100 CR, students, because you are subscribed to share capital, na? Obviously there will be cash in bank. This account debit, cash in bank account debit to share capital. So he has pumped the money where? In ZPLC. How much? 100 crores. Now what he do? Be careful, now the game begins then. Now the real game begins. Here, now 80% of this went to India. 80% of this went to India and 20% is to some other foreign asset. Other foreign asset. See the game. 80% went to herein to India and 20% is going to other foreign assets. 80. And then 20% student is to go into other foreign assets. Now if you see 80%, obviously we'll take RIL only. So shares of the RIL. Okay. Shares of the RIL. Have you all copied up till here? Okay, so far so good. So now after investment, obviously his balance sheet, if you see share capital on the liability side, asset side, 80 crores investment in RIL shares, 20 crores investment in the some foreign assets. That is how his balance sheet will appear, na? Because we know that at least whatever it be, sir, we don't know. Balance sheet should tally. That is the only concern that we always have. How it tallies, that's a different story. So share capital, and then thereafter you have the shares of the RIL, 80%, and the 20%, that is 20 crore, is a foreign asset. Now the game begins again. Now you all are aware that, say for example, students, over here, the growth rate of the RIL, students, the growth rate of RIL is 40%. The growth rate of RIL, students, is 40%. Now what will happen? With this growth rate of RIL being 40%, what happens? What is the impact? The fair market value of the shares of RIL will increase. Isn't it? The fair market value of the shares of the RIL will increase. Now let's see the ripple effect. What is ripple effect? The ripple that creates when you throw a stone on a still river. The ripple happens. See the ripple effect over here. With the shares family of the RIL in the market, it is going up and up. It will have the impact on what? The fair market value. Can I say the fair market value of the investment? Investment of what? Investment of ZPLC also will go up. Isn't it? All of you agree on this one? If the fair market value of the shares of RIL, if that goes up, then the fair market value of the investment of ZPLC, that will also go up. See the ripple effect now. So if my asset value will increase, if my asset value will increase, so don't you think that if my fair market value of my asset increases, although the book value can be anything, but if the fair market value of my assets increases, so don't you think that my face value of the shares will be 10 rupees per share? My face value is say 10 rupees per share. Don't you think that even now, if my fair market value of the asset will increase, it will have the impact on my fair market value of the share price in the market. So what happens now? Because of this, what happens? In this case, the fair market value of the share price of ZPLC will also increase. What I've written? The fair market value of the share price of ZPLC, will that increase or not? And the answer is yes, it will increase. So just take it the same way over here for timing rule. So now if you see over here carefully, say for example this is again rupees 100 per share. This is an example. 100 per share. As an example for us. Now you tell me what happened in this case. The XINC dot is transferring what? The shares of YINC dot. Ultimately this is what is going to happen now. The transfer of. Now, can you see this? What is happening over here? The transfer of what? In this case, you only tell. Indeed, the transfer of the shares of ZPLC at rupees 250 per share. Transfer of shares of ZPLC at 250 per share. Isn't it? Now just have a look at, just put it 1, 2, 3, 4 and 5. See the ripple effect game. The 1, 2, 3, 4 and 5 is the ripple effect. I hope that all of you are clear with this one. In this scenario. So now with this particular part, the question would be what? The question is whether the capital gain arising on the transfer of what? The shares of ZPLC will be taxable in India. Whether the capital gain arising, what is the capital gain? 150 per share. So whether the capital gain arising on the transfer of shares of ZPLC, will it be taxable in India? Now, XINC dot will say, in question number 1 only you people said what? Shares of a company is said to be situated at a place where the company is incorporated. So ZINC dot is incorporated where? ZPLC is incorporated where? In Singapore. So the shares of ZPLC is situated in Singapore. So if the capital gain, if at all has to accrue, where it has to accrue? In Singapore. And then it is between USA and Singapore. India, you don't interfere in our matter. That is a statement. So, What can be done? In this case, this is what exactly was a Vodafone. You are selling a shares of a foreign company. That foreign company incorporated outside India. And just now you all told in question number 1, shares of a company is said to be situated at a place where the company is incorporated. This is incorporated where? In this case, this is incorporated in Singapore. So, capital gain is accrued in Singapore and the rate of tax is only 10%. We'll pay tax in Singapore. We don't want to pay tax in India. So, see what has happened from question 1 to question 2. What has happened? Say, base erosion, profit shifting. Do you all agree? From the base which was there in India, it got shifted where? To Singapore. See, you people are getting checkmated. Because you answered already question number 1. And now you are trying to find the answer, but how this is possible? That the nationality is coming. And it should have been taxed also here also. Because deep down a voice is coming. And whatever it be, ZPLC is not having its own value. Whatever is the valuation at which XINC dot has transferred the shares of YINC dot, that valuation of ZPLC is coming from India. Otherwise, ZPLC is nothing. A company which is without any commercial substance. What it is? Investment company. Making investment where in India? And some other foreign country. But the bulk of the investment is in India. The Indians are flourishing. The Indian asset flourishes. And that is throwing the valuation to whom? To all the foreign assets. Investments. So the Indian growth is giving the valuation to the shares of the foreign company. Because you have made investment in India, therefore you are getting the valuation. Therefore what? You are getting the valuation. And accordingly, because of that valuation, there is a capital gain. So the capital gains has got nothing, there is no contribution as such of ZPLC. Whatever is the contribution, 80% of the contribution is because of Indian asset. 20% you can give the contribution to whom? To the foreign asset. But 80% contribution is of the Indian asset. That's where the valuation comes. And therefore, India should have what? Should have the right to tax it. But in question 1, you already set up the provision. You only told the provision. What? That shares of a company is said to be situated where the company is incorporated. And now you want to drift from that. Now you said, no. But India is also there in this case. Because India is throwing the valuation to ZPLC. But now you are blowing hot and cold. This is inconsistency. And this is what Supreme Court found out in that Vodafone case. Why? Because question number 1 you said what? Shares of a company is located at a place where it is incorporated. So now you stick with that particular logic only and give the answer for this. Then in that case you lose the ground. You cannot tax it. Now your ground is that, fine, I admit that. But you are saying, but what about ZPLC? It is not getting its own value. The valuation of that 250 per share, it is because of 80% is coming from the Indian asset. 20% we can say from the other foreign asset. So substantial valuations are coming from Indian asset. So how is it that the India cannot be a party to this transaction? But the Supreme Court said, fine, but be careful. You are interpreting deemed income provision. It's a deeming provision. No? Income deemed to accrue or arise in India. And any deeming provision, if you have to interpret it, it has to be interpreted in a very, very strict manner. Meaning, show me the provision where it is written. That if you sell a shares of a foreign company, still it can be taxable in India because of the economic advantage coming from India, where it is written. Is there any provision? Yes, we agree to this fact. Your argument is all fine. What is your argument? Argument is that ZPLC does not have its evaluation. The 250 per share from 100 to 250 contribution is of the 80% contribution is coming from India. So therefore, that gain, the economic advantage, which is that gain of 150, 80% of which is coming from India. So there is a nexus with India. And if there is a nexus with India, therefore it should be taxed in India. What the Supreme Court said? Agreed. Whatever you are saying. But you are traveling in section 9. What is section 9? Income deemed to accrue or rise in India. And if income is deemed to accrue or rise in India, a deeming provision has to be interpreted in a very, very strict manner. Which means, show me the provision where it is written that a foreign company share, if transferred, on that the capital gain could be taxed in India because of the economic advantage is coming from India. We need the provision. And without a provision, there cannot be a taxation in a deeming provision. So deeming provision has to be very specific. Because just now you told me, I told you this one, na? Remember the first example that we started? I told you that Singapore example, you went to Singapore, you had a house property in India, you were trying to sell off, you could not sell. And then you found that particular person in Singapore to whom you made an agreement in Singapore and gave it on rent. I asked you that question, where it got accrued. All of you went into that economic advantage theory, India. And where is the accrual? Accrual it is in Singapore. Why? Even if the asset is in India, economic advantage is coming from India. Doesn't matter. What is important? In this case, where the transaction has taken place. The transaction took place in Singapore. Accrual therefore is in Singapore. Transaction took place in Singapore. Accrual is also in Singapore. Therefore, tax also will be in Singapore. But no. But the economics advantage, house property is in India. So now on the basis of that, if you want to tax it, yes, there is an excess which is getting established. But please understand, if you don't put up specifically that nexus in the law, you cannot tax it remaining silent. Why? Because the accrual is outside India. So deemed accrual, through the deeming provision, if you want to tax it by showing the nexus, by deeming provision, if you want to tax it by, if the deeming provision, if you want to tax it by showing the nexus, you need to show specifically the nexus in a provision itself. And if the provision is silent, it cannot be taxed. So therefore, in this case, we said that, okay, now the provision was introduced. What is the provision? If the asset property is situated in India, then the income arising from that asset property or source situated in India, the income arising from that is deemed to accrue as in India. Income arising from that is deemed to accrue as in India. So similarly, over here also, right now if we have to discuss this, the provision is that capital gain or the transfer of capital asset situated in India is deemed to accrue as in India. Capital gain arising on transfer of capital asset situated in India is deemed to accrue or arise in India. So what do you have to show? The capital asset in this case is a share of ZPLC. Where it is situated? Right now it is situated in, as per the normal discussion, it is situated in Singapore. If it is situated in Singapore, as per the provision, then going by the provision strictly, why strictly? Because you are interpreting which provision? You are interpreting deeming provision. And deeming provision has to be interpreted in a strict manner. So now going by that interpretation, strict interpretation, you will say that, okay, ZPLC share is situated in Singapore. And hence, in this case, the capital gain will also arise in Singapore. Then accordingly, nothing is taxable in India. Now that nexus that you want to establish within India, you will have to put up in a provision. Without a provision, you cannot tax it. Without a provision, you cannot tax it. Is that point clear to all of you students? All of you are clear? Exactly the point. This is what has happened. In the Vodafone students, if I have to tell you, telecom company students, you all are aware, telecom company. Only one company has really earned big money in telecom sector. Only one company, which has really earned big money. Which company? Any company. In India, I'm only talking from Indian perspective. Anyway, past, present, future. Apart from the government, MTNL and BSNL, forget that. Forget MTNL and BSNL, the private sector. Geo is in a destructive model. They want to do a disruption in this sector. So their model is completely different. Geo model is like this. You are having Airtel, you are having Vodafone, we don't care. You will have to have another number which is Geo. That is their model. So anyone having Airtel, anyone having Geo, or anyone having Vodafone, fine, you keep it. Who is saying no? Take another number. And that another number has to be Geo. That's their game plan. Isn't it? This is what they are into it, nevertheless. It's not Geo right now. It is Hutchinson. Heard of it? Hutchinson, SR Hutch. Hutch is a player. In 1999, in the year 1999, students, the policy of that then government was to have a telecom revolution in India. That was a green revolution. Then there's a telecom revolution. So I think that was an NDA government, if I'm not mistaken, 1999 when they entered. Telecom minister was Mr. Pramod Mahajan. I was listening to that speech because I just started my CA journey then at that point of time. So I was just into the speech of this person, and then I heard this particular speech wherein what he said was that their vision is to ensure that the landline, public should consider this landline as expensive mode of communication. And the handset is what probably would be there across the country with all the people. And today we see that thing. Everyone. Landline, nobody has got it in this case. This is the era that we are in now. And that is the telecom revolution. Hutchinson came to know this. Because before that, what was the scenario? Mobile phone was, incoming was, I think 16 rupees or 20 rupees per minute. Outgoing was 32 rupees per minute. And that too, the mobile phone size was like this. Huge mobile phone. And that was a scenario. So that was a game. And then suddenly now, telecom revolution, where what will it mean? Incoming free? And outgoing what? In paise you can have it per minute. That is the kind of situation that we are having right now. So this is the revolution that has happened. Hutchinson came to know that whatever profit or the cream that we have to extract in this telecom business, we have done it. Now the cream will not be there in the next 3-4 years from now. And what therefore they did was that it's time. Time for what? Exit. It's time for exit. So they started what Hutchinson India, they started floating one by one a company beyond that. And every particular company was an investment company. So one company was investing in India, the share, that was a holding company. That holding company was further being invested by some other company. That further was being invested by some other company. The structure was happening. And at the 14th level above, there was a company in Cayman Islands. It was one share company in Cayman Island, one share company. And what happened? In this case, Hutchinson had transferred that one share of that Cayman Island company to Vodafone. Okay, that 14th level, India is on the ground floor. And above that, there are the investment companies above, and it went to up till where? Up till, in this case. In that Cayman Island, on the 14th floor was Cayman Island. That Cayman Island, one share company, one share was transferred to Vodafone by Hutchinson. And on the transfer of that, it was a multi-billion dollar deal because that one share value was multi-billion. That was a valuation that was there of that one share in Cayman Island. What it does nothing. Only was investing in the other company. That company was investing in the downward company. That company was investing in downward company. And finally, that company was finally investing where? In the Hutchinson telecom business in India. That is how the entire chain was established. And you have sold the topmost chain share. Which was the topmost chain share? One share of the Cayman Island company. Hutchinson selling it to Vodafone. And through that, Vodafone got the control of that company. And once they got the control of that company, finally they got what? Control over what? The telecom business in India. Because through that, they were exercising the control on all the downstream companies. And finally, ultimately, to the Hutchinson telecom business in India. And that's how Vodafone entered in India. That was a multi-billion dollar deal. So from where this valuation is coming, multi-billion dollar of all these of that company? Is it because of that Cayman Island? It is situated in a very good place, Cayman Island. Was that giving the valuation? No. The valuation was because of the telecom business of Hutchinson, which was situated in India. That was throwing the valuation to the above company. The capital gains was being the capital gains was huge. And on that capital gain, if I apply 20% rate of tax, the tax amount in INR is 12,000 crores. Just imagine the value of the transaction, and after value, you reduce the cost of acquisition, you will get capital gain, and on that capital gain, apply 20%, which is the rate of tax. The rate of tax, then you get how much? The tax amount was 12,000 crores. That was the tax amount. You just imagine the valuation then. What kind of valuation it was. They didn't pay any tax. No TDS was being deducted. No tax was paid by Cayman Island. Foreign company, whatever discussion that we had. So therefore, anything accrued, it is in foreign company. Government with all right from the finance ministry. That transaction happened in 2007. Hutchinson made an exit. And then once they made an exit, without any tax in place, no tax was being paid, and they went. Vodafone came. Nobody paid any tax. Nobody paid anything. Entire government machinery, right from the finance minister, ensured that this tax had to be paid. Assessing officer passed the order. First order, assessment happened. Assessment, they said that it will be taxable in India. It went to the appeal, further appeal with the Commissioner of Income Tax Appeal. They said that yes, the tax has to be paid in India. It went to the tribunal, ITAT. ITAT also said yes, the economic nexus is there with India. And because the economic nexus is there with India, therefore the tax has to be paid in India. It went to the Bombay High Court. The jurisdictional High Court was Bombay High Court. Bombay High Court said Justice Chandrachud, who is now the Supreme Court Chief CGI, this stage, that time he was the Chief Justice of Bombay High Court. Now the present Chief Justice of the Supreme Court. He also said the same thing, that yes, there is an economic nexus which is established, and hence what? Pay the tax in India. The matter went into the Supreme Court of India then. Understand one thing, huh? Vodafone was losing the case up till now. And the battery of lawyers they have appointed in this, when the matter went to the Supreme Court, at that time the CGI, the Chief Justice of India, was S.H. Kapadia. who recently died. So that CGI, S.H. Kapadia, a Parsi fellow. First, the Supreme Court CGI said, Vodafone, you are losing the case right up till Bombay High Court, and you have not paid a single tax. You have taken a stay on the demand raised by the Income Tax Department. So before we admit your case in the Supreme Court of India, pay 3,000 crore as a deposit. Pay 3,000 crore as a deposit before we start hearing your case, because you are a loser right now. Till High Court you have been lost the case, and you are not paid even a single money. You are waiting for what? It is 2011 now. 2007 this demand was raised. It is now 2011. Not even a single money has been paid. Paid 3,000 crore as a demand immediately, and then we will take up your hearing. Vodafone paid 3,000, and then they replaced their lawyer. Harish Salve was bought in, and this is what exactly the argument he has put up. Out of the series of the argument, this was a clincher. The deeming provision, if interpreted, has to be interpreted in a very strict sense. Yes, there is an economic nexus. Yes, there is all the things which are there. But where is the provision? And a multinational company making an investment in India, they go as per the letter of law. And when they did not found this in the law, in this case, they did the investment in this case. And that's the reason why they did the investment. That's the reason why they did the transfer. Now, without a law, primarily you want to tax it. That too in a deeming provision. And the Supreme Court bought this argument. And they finally said what? Yes. Without a provision which establish the nexus, the transaction cannot be taxed. And hence, the capital gains on which the tax is 12,000 crores will not be taxable in India. Will not be taxable in India. Then I told you the fees of Mr. Harish Salve also in this case. I told you were interested. I'm not getting confused what I said here and what I said there. I'm not that aware of it. So, how much was his fee? The fees that was being given to him primarily was 380 crore rupees. 380 crores. And this is what he gets it. Why? 12. You will say, how come this much is fee? You just imagine 12,000 crore, otherwise they have to give. For that 12,000 crore, 380 crores is peanuts. Not even 10%. Or not even 5%, I must say. 2% is the fees actually in this case. So what's the big deal for the Vodafone? Otherwise they would have ended up paying 3,000 and they got 3,000 crore with interest. So they will say that interest is what we would have paid it to him. All are happy. But then the government, you can imagine, 12,000 crores is gone. What anticipation was high, na? 2012, they made the amendment in the law. And that amendment was made with retrospective effect. 1961. That how can government be a loser? Government cannot lose it. So we will lose it, but then officially at the time of ceremony, the trophy has to go to the government. Even if we are a loser. And that is what they did in the floor of the parliament. I will share a speech with you of Pranab Mukherjee, the then finance minister. That was a gutsy move. And I must say, the price that he paid was, he knew that after this amendment, if I do, my finance ministry is gone. Because the kind of pressure which that will be there on India from all the foreign lobby would be huge, unsurmountable. And he knew that his position is out. He is out from this finance ministry. But he said that if somebody can do it, it is only I who can do it. And he did this. What he did, made the provision, and that provision was made with retrospective effect. 1961. And he gave his reasons for that also, but that I will not go in the reasons part. And then once the provision was put in place, they said that Vodafone, it's retrospective. And because it's retrospective, pay the tax now. And then Vodafone says that, what kind of country you are? Is it like a banana republic? We won the case and now you say you want to tax it? Through a retrospective amendment, they went to the international court. International court. They took this particular case through the UK and thereafter the international court in Hague, where this Kulbhushan Jadhav case was also being fought in that Hague, isn't it? And there they went and they fought this particular case, and in just very recently, in 2019 or so, the judgment came. They said that this is an invalid particular way to deal with the foreign investor. A very high-handedness has been shown by the then government to give it. India by then they have said it, let it be. Let it be, because by then we also moved on. 2019, 12, 19, we said it's fair enough, not an issue. Okay, so that is what it is in this context. So this is what it is. So therefore, what is the provision? The ultimate game is what? Ultimate game, students, is, in this case, is that provision. And what is the provision? Quickly. That the magical provision. Explanation number 5 to section 911. Explanation number 5 to section 911. I will explain this provision through that case study which is there in front of you. Where the share of the foreign company in the bracket ZPLC derive its own value substantially from an Indian asset then the share of such foreign company in the bracket ZPLC is deemed to be situated in India. Then the shares of such foreign company is deemed to be situated in India. Yes, Ram. Indeed. Then the shares of such foreign company is deemed to be situated in India. Have you all copied all this? All of you? So this is what it is, students. You can see now the impact of this particular transaction. So what we have to determine whether ZPLC derive its own value substantially from an Indian asset. If yes, then don't say this word. Then ZPLC is an Indian company. Did it change the character of the company? They don't change the character of the company. What they change is the location of the shares of that company. Through this provision, what they are effectively doing is they are not changing the character of the company. That now, because you are deriving your own value substantially from the Indian asset, therefore foreign company, you are an Indian company. No. What they have done? They have changed the location of the shares of that foreign company to be where? In India. To be where? In India. This is what they have done it. Okay, so that is how the things are being there. Also, one more error. So this is error number one, which I told you, that you may get carried away and you may say that then the share of then ZPLC would be considered as an Indian company. This is the first wrong sentence on your part. Okay, then there is one more wrong sentence that you will have. What is the second wrong sentence? You will say that where the shares of foreign company derive its own value substantially from an Indian asset, then the capital gain is deemed to accrue in India. Why you are doing a direct conclusion? First, at least you are jumping to the second floor without stepping to the first floor. So you have to say that where the shares of a foreign company derive its own value substantially from an Indian asset, then the location of the shares of the foreign company will be deemed to be in India. The location is in India, and because the location is in India, therefore the capital gains arising on the transfer of shares of such foreign company will be deemed to accrue or arise in India. So don't jump from here that because you derive your value from the Indian asset, because you derive your value, substantial value from the Indian asset, therefore what? Therefore capital gain is accrued in India. Don't do that. Don't bypass this step. Don't bypass it. Write it properly, stating that then the shares of such foreign company is deemed to be situated in India. Once that has been written, then you conclude it by saying, therefore capital gain arising on the transfer of such shares will be deemed to accrue or arise in India. I hope that all of you are clear with this one now. Every one of you. Now the main issue, students, is this. The substantial test. This is the main issue. This is the main issue. Substantial test. Do you all agree? Now what is this substantial test, students? Quickly. So substantial test. In this case, in this situation, there are two things. Be careful, students. When to test, and second one is how to test. When to test and how to test. So now if you have to put across when to test. So there are two dates which has to be considered. So when to test is the relevant date. What is the relevant date to test this substantial condition? On which date we should check that whether ZPLC is deriving its own value substantially from the Indian asset. For all the 365 days we have to see? No. There has to be some date, on which we have to check whether ZPLC, are you deriving, you have to ask question on that date. On that date you have to ask question to ZPLC that whether ZPLC, are you deriving your value substantially from the Indian asset? So which is that date on which this question will be asked, and on which date the test would be applied. That data is the first thing. Generally we say balance sheet date. The balance sheet date is there, don't worry about that. But apart from that balance sheet date, there is one more date. Please write with this question. On that basis, we'll decide the date. Whether the aggregate book value of all the assets of the foreign company in the bracket ZPLC as on the date of transfer of its share, the rate of transfer of its share is more than 15%, is more than 15% compared with the aggregate book value of all its assets, aggregate book value of all its assets as on the last date, I can say balance sheet date, preceding the date of its transfer, preceding the date of its transfer. The answer to this question can be yes or no. So yes means more than 15%. No means not more than 15%. That is what it will mean. Na? So read this once again. Once you are written it. Fine, students. So if the answer is yes, the value has increased by more than 15% as compared to the balance sheet date, last balance sheet date. Then when they said if it is increased, so go with the latest data. So therefore, the relevant date in this case would be the date of transfer of its share, the date of transfer of its share. And if the answer is no, no means in this case it does not increase. So you can say the date, the balance sheet date preceding what? The date of transfer. So first at least decide which date you want to test it. You cannot keep testing this for the 365 date. There has to be some date on which we have to decide whether ZPLC, the Singapore company, does it derive its value on that date? Does it derive substantial value on that date from Indian? We cannot keep testing this condition for 365 days. It has to be some date. Which date? That is decided by this first. Once this date is freezed, then what? Now you come to this. How to test? So, how to test? That is the game. So, over here, on the relevant date, RD is the relevant date. On the relevant date what? Two things. On the relevant date, point number one, whether aggregate fair market value of the investment in the Indian asset. In the Indian asset is more than rupees. What? 10 crore. Is more than rupees 10 crore. So that's the first condition. That's the first condition, students. And so there are two things, huh? This plus this. And what? So therefore never think that this is or, this is and. And point number two, the aggregate fair market value of the investment in the Indian asset is what? Is greater than or equal to 50% of the aggregate fair market value of all the assets of the foreign company ZPLC, of all the assets of the foreign company ZPLC. This is, students, the absolute condition. Absolute condition, whereas this is relative condition. Do you all agree? The absolute value of the investment, made by ZPLC in the Indian asset should be more than 10 crore. The absolute value of the investment made by ZPLC in the Indian asset should be more than 10 crore. This is absolute value. And what is the second one? Relative. Now relative is, okay, versus this, versus all. In my example, if you remember, 80% it was. In my example, 80% and then 20% in that your other assets, isn't it? Foreign assets. Indian asset contribution was 80% on the total value. Now here, students, one thing you should be careful about it is that here the value has to be in the fair market value terms. This discussion we will not have it today. This FME particular part. We will keep it for next particular session. But this is what it is. I hope that all of you are clear with this one now. So first freeze, what is the relevant date? Two dates has been given. Date of transfer and the balance sheet date preceding the date of transfer. Check one of the two. Second condition is what, students? The second condition in this case is as on the relevant date, what do you have to see in this case? One, whether the fair market value of the Indian investment held by ZPLC, is it more than 10 crores? More than, not more than or equal to. And what about the second one? In this case, whether the fair market value of the Indian investment is at least 50% of the total fair market value of all its assets. Whose assets? ZPLC assets. And if both the conditions are satisfied, then we will conclude that yes, ZPLC is deriving its value substantially from the Indian asset. And if that is the case, then the location of the shares of ZPLC is situated where? In India. The location of the shares of ZPLC is situated where? In India. Is that what clear to all of you? Every one of you? And that exactly is the point. If you all are clear with this one, let us assume now this condition is satisfied. And if you assume that this condition is satisfied, then the conclusion will also follow. What is the conclusion? That ZPLC, the location of the shares of the ZPLC would be situated where? In India. That is the conclusion. No? And if that is the conclusion, then the transfer of shares of ZPLC will result into a capital gain which is deemed to accrue rise in India. That is how one follows other. The one follows other. Do you all agree to this one or not? And that exactly is the game. So if that is the case, students, now be careful. This entire case study that we have introduced, students, was targeting whom? XINC dot. He is the architect of this entire thing. He did this because in case study 1, he got the taste of what will happen if I do a direct investment in India and then do a transfer. That's how he did this. And to target XINC dot, to stop him to do his nefarious activity, illegal thoughts, tax evader thought, to stop him. That we have introduced explanation 5 to section 911. Explanation 5 to section 911. Isn't it? And if that is the case, I told you that he is a 90% shareholder. It means 10% there will be someone else na? Also. So say for example, just I have to just give you an example over here. What is that? Say there is one Mr. A having 2% in this. Mr. A is having 2% in this. And then Mr. A is also transferring the share of ZPLC to say Mr. B. And just now we concluded that ZPLC derives its value substantially from Indian assets. So therefore ZPLC shares location is where? In India. That is what we concluded. So if that is the conclusion, then the question to all of you would be that the Mr. A selling the shares of ZPLC will have the capital gain which is deemed to accrue rise in India. Because he is selling the shares of ZPLC which is deemed to be situated in India. Then argument purpose you all will say, then sir in that case the shares of ZPLC being deemed to be situated in India, the capital gains arising to Mr. A on the transfer of the shares of ZPLC, that capital gains also will be deemed to accrue in India. But the government was not interested in Mr. A. The entire thought was not Mr. A, XINC dot. So then the government created a threshold that on whom this provision will not apply. That is minority interest. And they have said that a person who is holding not more than 5% of voting power, 5% of voting power in that foreign company, on them this provision of indirect transfer will not apply. Which means even if ZPLC derive its value substantially from the Indian asset, even if because of that ZPLC share is deemed to be situated in India, still what? Still to a minority shareholder transferring the shares of such foreign company, the provision of 911 will not apply. No capital gain. That is what it is. And therefore, students, just write over here once you are done with this non-applicability. Of section 911. Any shareholder of the foreign company in the bracket ZPLC who does not own more than 5%. You can just write like this one, non-applicability of 911 in the bracket explanation 5. Any shareholder of the foreign company ZPLC who does not hold more than 5% of the voting power of such foreign company will be outside the purview of explanation 5 to and hence the chargeability will not be attracted. Chargeability will not be attracted to such shareholders on transfer of the share of such Is that clear to all of you? We will do one case study now. Okay, that will help you the there are two case studies. The second one is the ultimate one, but that I'll do it in the next. We'll do a case study now from over here. Be careful in this case. So therefore, I want all of you to take this question number 5, page number 37. Students, you will here, what you will do, you will only read it up till here. Based on that only you will conclude. You will read it only up till here. Based on that only you will conclude. So, Sienna, a company incorporated in Mauritius, is a wholly owned subsidiary of Sienna Inc.UK. So just like we had Singapore in between, here we have got Mauritius in between. And we had USA, na? The holding company was USA. Who is there over here? Sienna Inc.UK. So next is Sienna UK enter into a share transfer agreement with whom? Synergy PT, a Singapore company, to transfer the shares of its subsidiary Sienna Mauritius. The agreement has been entered in UK. Synergy Singapore has provided sale consideration in US dollars from its UK bank account. Now read this table, students, very carefully. Sienna Mauritius has certain tangible and intangible assets located in India. Further, the following information is provided. All of it. All the three situations are independent to each other. So first what you are going to decide? The relevant date. Here the book value and the fair market value is the same, students. So when you will do each situation, 1, 2 and 3 are independent to each other. And as I told you, that first determine which date. Will you go with 25th June or 31st December 2022? Once that is decided, then on that date, the two tests, absolute test and the relative test, satisfied and conclude quickly. So I hope that all of you would have gone through this, and the solution is also given for the application how it has to be considered. All of you got the answer right? in this case. So this is how students will have to look at it. If you see in the first case, point number 5, can you see that? Exactly it is 10 crore, Indian asset value. And because it is exactly 10 crores, therefore, that substantial condition is not fulfilled. And if the substantial condition is not fulfilled, the conclusion you are now, all of you are aware of it. I hope that all of you are clear with this one now, every one of you. So this is all of it, students. In this context, fine. So next question we will do it in the next class. So that's an ultimate question. Okay. So I'll see you then in the next session, students. Revise this because this is now done of this 911, which has been no, not homework. We'll do it together because it's a very something more is there in that. So don't do as a homework. We'll do it together.